was actually the one who is the lookout. He is the one where recovery has been effected from. Gold items were found from him. He was also identified in the TIP. Similarly, the second petitioner is the driver of the vehicle. These are the actual perpetrators of the crime who walked into my home, violated the sanctity of my premises, tied up my sister, held a gun to my 6-year-old niece, Lordship. I was also injured.
Just cool down. Is whether a person can continue to be incarcerated as under trial prisoner. If he has done the offense, he will be sentenced to imprisonment.
Great.
Now, this trial is not likely to over in near future. There are more than 72 witnesses.
Well, 22 now. 22 now.
All other 50 have been dropped.
My lords, our statement is made in the earlier round, which is at page 32, my lords, as well as in the impugned order. So those are my instructions, my lords.
They have said that even before the lower court, Lordship. This is a stand of the state that only 22 witnesses will be dealt with now. Lord, may kindly see page 2. It says, learned advocate for the state and learned advocates of the de facto complainant strongly opposes the prayer for bail. Learned advocate for the state states highest 22 to 24.
We'll tell you the trend in high courts. Where case is made out for grant of bail, courts are reluctant to grant, and courts already decide the case within 6 months without knowing what is the pendency in that court, just to give psychological satisfaction to everybody. Such orders don't work, and such orders are not permissible in the light of constitutional bench.
My lord, may kindly see, this is not just about expediting the trial. Kindly have page 2 for a moment.
Yes.
My lord will see. Just if I draw my lord's attention to paragraph 4 on that particular one. It says, our attention is drawn to the material in the case diary.
Correct.
There are eyewitnesses naming this petitioner as having participated in the alleged offense. The petitioner has been identified in the test identification parade. There are also recovery from the petitioner. Therefore, on an overall consideration of the gravity of the charge in the material on record, with prima facie incriminating the petitioner, we are not inclined. My lord, the actual bail has been rejected on merits. Lordship, if such perpetrators of such grave dacoity are permitted to the liberty of bail, my lord, it would probably be, in my respectful submission, a travesty of justice. As I said, my lord, 6-year-old niece was held to account.
We'll tell you, if somebody says that our orders are causing travesty of justice, we don't get provoked. Ultimately, we have to pass orders in accordance with law. Somebody may say the orders are wrong. Somebody may say the order will cause travesty of justice. We are not concerned. We don't get provoked. We are trained not to get provoked by such comments.
My intention was not to provoke, my lords.
No, we won't get provoked by such things. We are trying to tell you the same thing. Leave granted, heard learned counsel appearing for the parties. Learned counsel appearing for the state on instruction states that there are no antecedents. Initially, 72 witnesses were named, out of which only 3 have been examined till today. There is a statement recorded in the impugned order that the witnesses will be brought down to 22 to 24. Next paragraph. The trial has been delayed considerably. When there are no antecedents, there was no reason for the High Court to deny the bail. Next paragraph. We have repeatedly observed that while rejecting bail applications, the High Courts are passing orders directing disposal of trials within a time schedule. Apart from the fact that such directions are contrary to law laid down by the Constitution Bench in the case of High Court Bar Association, Allahabad versus State of UP and others, 2024 6 SCC 267. Such orders put undue pressure on the trial courts, which are already flooded with lot of work. Unless the situation is extraordinary, High Court should refrain from passing such orders as held by the Constitution Bench in the aforesaid judgment. Next paragraph. Considering the facts of the case, the appellants are entitled to enlarge on bail till the final disposal of the trial. For that purpose, the appellants shall be produced before the trial court at the earliest. Trial court shall enlarge the appellant on bail on appropriate terms and conditions. it will be, the state, council for state will be heard on terms and conditions. It will be always open for the council for state to urge that stringent conditions shall be imposed. Appeals are accordingly allowed.
Wait, please. What's the question of a work?
And challenge the act,
Yes,
withdraw it, then all sorts of proceedings are filed instead of filing
I
37.
agree. It's a mess. We had
Complete mess. And why should we
four,
entertain SLP?
4 rounds of it. But I'll tell you,
There's some limit to such
there are
things.
two peculiarities I find here, and I'll just place that. One, this plant, we are just an SPV, we are executing it. Now, this plant,
You are taking all courts for ride.
no, I just want to,
Right.
just allow me to make the
Right.
submission.
And
This plant,
actually we'll tell you this petition was withdrawn from Supreme Court with the,
with liberty.
to file 37 actually. And then you file all sorts of proceedings thereafter.
I'm trying to say it's because we didn't say 37, we may not be bound to have gone in 37, but I know your
Not a case, not a case.
your lordship, and I read between the lines, but
Not a case.
please leave that aside and just for a minute.
How
Just,
many proceedings you are going to file? You have suffered an award, section 34 has been dismissed. How many more proceedings you want to file?
can I just tell you the
And how
difference?
much is the award?
52 crores.
Deposit the money, then we'll entertain all these nice litigations, the real litigations.
May I tell you what the peculiarity is? There is another proceeding arising from the NJT, which is before this bench. There your lordships have been told that the entire project remains incomplete. There are power plants to be constructed. This very project.
Sanctity to any proceedings, the
I
award is final,
So,
section 34 has become
ignore
final.
that for a minute. Just ignore that.
Can't ignore that.
No,
That's
I'm
the
telling you,
problem.
there's a
You
larger
can't-
question.
Right.
Larger question. Just please bear with me just for a minute, because the consequence before this minute and after this minute may be the same. So just for a minute, there is this other NGT proceeding which has come before your lordship.
Yes, you have mentioned that.
Yes.
Right.
Now the reason why we mention that is this: in those proceedings, your lordships have been told that the project remains incomplete. The entire award, etc., here proceeds on the basis that they have in fact completed the project. The onus is on me to show that it's not complete. But in those proceedings which have come here, it's the very same plant, and the fact that that effluent treatment plant and everything else, including the plants around it, have to be completed. Your lordships have given directions for its completion.
Yes.
Now, the consequence of this present proceeding is, if your lordships don't interfere with the award, if your lordships are willing to sustain the fact that
Yes.
works contracts will come with an MSME, we believe that it shouldn't. 3 high courts have held that works contracts don't come with an MSME. That issue is pending before this court in a separate batch of SLP. If your lordship don't interfere there,
Yes.
the same plant which your lordships in that proceedings are saying, please proceed, is being attached today in the execution here.
All right.
So I'm saying because of that peculiarity alone,
Thank you.
there will be
No case
well,
Article
there will be some inconsistency, because when that matter comes up, your lordship will be told that the plant has been attached.
We'll see that now. Yes.
Very well, ma'am. Leave it at that. Well, this works contract issue is pending here, because it is a works
Your
contract.
conduct is such that can't be entertained. Yes.
Very well.
Please for the respondent.
Your Lordship, I'm therefore the respondent is your lordship. Learned Deputy Advocate General was supposed to appear. Somehow he.
No, they sought Passover.
This is not fair. Huh? That's
I-
you sought Passover.
I've recently, whatever I
and
could go through, I could
just
assist
see
your lordship.
9 years and 9 months undergone. Appeal of the year 2017 not likely to be heard. This is Madhya Pradesh High Court.
Your lordship.
You
No,
have
5
6
months.
days in filing FIR. Out of 20 years, almost 10 half undergone.
No,
You have
now,
not placed any material on record to show antecedents. Please your counter. Go to your counter.
now Lord, he has undergone the 10 years.
Almost 10 years.
Almost 10 years now.
That is of
And
you.
counter, you don't say about any antecedents.
There is no antecedents, Lord.
No antecedent. Sorry.
Review granted. In our view, High Court ought not to have rejected the prayer for grant of suspension of sentence and bail pending the final disposal of criminal appeal pending before it. Now, the appellant has undergone half of the substantive sentence. appeal is not likely to be heard in near future. In the counter, no antecedents of the appellant have been brought on record. Therefore, the appellant is entitled to suspension of sentence and bail pending the final disposal of the appeal before the High Court. Next paragraph. Appellant shall be produced before the trial court at the earliest and shall be enlarged on bail pending the final disposal of the appeal before the High Court on appropriate terms and conditions.
Lord, that one-page instruction I'd handed over.
No, what was your prayer before the High Court? Just where?
Prayer was for quashment, not on the ground that the predicate offence is gone. I'll place to your lordship, not just have a look at this index of orders I passed before you.
No, just show us the prayer.
The High Court.
Prayer before the High Court.
Just a moment, Lord.
You have seen the report,
So this is your.
you have seen the report, we have given copies to the prayer.
Lord, the prayer will be 177. 177, Lord. 177, sir, in the High Court.
So it was for questioning the proceedings of CJI.
Yes, Lord.
Now that petition was allowed.
Yes, Lord, that was allowed because the predicate offence had gone on in this case. Just see that chart I have handed to your lordship. Just see this.
No, now we thought that even respondent agrees, we could have disposed of the matter.
Lord, can I just point out what the position is? And I don't think they'll
No, he said the predicate offense is alive.
no, not as, no, it's gone.
No. See, even if there is no predicate, accused in PMLA need not be accused in predicate offense.
Lord, that's all right. But
Right.
as against me, it's gone. It's been quashed. Please just see three things, Lord. Please see this, what I've handed over to your lordship for a moment.
No, what we thought was, the respondent will take a stand so that we need not go in. Now we'll have to go into
Lord,
the
can I just take 2 minutes, Lord? Just see this.
No, what we are trying to say is, now we have to lay down the law, the manner in which High Court has acted. So we'll say that no further proceed on the basis of ECR and we'll hear the matter. We have to lay down the law in the light of the facts which are disclosed in the
Report, Lord.
report.
Well,
Otherwise, we are trying to find out via media.
yes,
If
Lord.
it's not possible, then we'll have to go into it.
But the biometer is not, my lord may consider quashing the proceeding because I'll show your lordship. Just see what I've handed over, Lord, for a moment. Your lordship will become clear.
No, therefore, but
But for that, the respondent has to.
respondent would have said that let this original order remain. We could have passed order in terms of that, but they want to contest.
He's
So
the
therefore,
VC.
we'll have to go into this question.
The respondent is on the VC.
Yes, Mr. Zoeb is there.
Yes, my lord. My lord, only difficulty is, insofar as one minister is concerned, Periyasamy, accused number 6, sanction was taken and the predicate offence survives to him, and that what my lord will find in this very paper book, that sanction was taken to him.
Lord Kwame, it has been refused and. When Lord Mr. Hussain wants to make an issue of it, I can't.
Lord, even though I'm not carrying,
No, I'm. अरे भाई ये उसमें है
The prayer in that criminal OP was for quashing ECIR. Several issues will have to be gone into, including the issue of the manner in which orders have been passed by the high courts, by the High Court. Taking this necessary and the board taking it.
Can I just take one moment, Lord?
Yes.
And that copy to them. Give them
Right.
this thing. Have you given?
List for hearing at the end of the cause list on 22nd November 24.
Grateful. Lord.
In the meanwhile, ECIR number CEZO, copy from page 177, and all proceedings based on ECIR will remain stayed. Even the proceedings of criminal OP number 0017762 of 24 will remain stayed. So we'll See, this issue will have to be thrashed out.
Yes, Lord. I've also tendered to your lordship, Lord, today, all the orders passed in the context of the co-accuse. So there are two sets. For one co-accuse,
There are wider issue. When the court pronounces an order,
I appreciate, Lord.
that issue will have to be resolved.
I'm not,
May I on that issue,
in
Lord?
agreement on that, Lord. In fact, I was pointing out, Lord, this is only to point out that in the past, Lord, there are orders where the predicate offense quashment has been upheld till your lordship's court. And more so, Lord, if I may just point out, in the context of those orders, ECIRs have been quashed on merits as also in cases where sanction was
We'll
given.
surely deal with that. Though there is no direct judgment of this court on this kind of contingency where court pronouncing the order,
Yes.
there are judgments of high courts. Please get those
Yeah,
judgments.
we'll get them.
There's one judgment of Kolkata High Court. There are
Because we are
judgments of
carrying a judgment of the Supreme.
May I only make, I'm not carrying a brief for Madras High Court, my lord, but I just want to point out, my lords have taken a view that even if an order is pronounced and not signed, it can always be recalled without any application from a party.
But the successful party is not required to be heard also.
They are required to be heard, and it appears, my lord, that the
Your party was not heard.
Lord, I'm sorry, there's a distinction between.
they are not required to be
That's
heard.
right. That's right.
There's a complete difference.
And in any case, the party was not heard. The petitioner was not heard by the court.
Party is not required to be heard prior to recall. I'll show those judgments. I'm not defending the action of.
Go into that. We'll go
Lord,
into
if that is the case, not then 362 maybe a dead letter. I think my
That's
learned
right.
friend is talking about
That's
civil
right. No, no,
judgments.
that's-
Civil judgments fall in a different context. Lord.
It is in the context of 362,
No,
this
this
judgment.
issue may arise in future, therefore we want to decide it.
Yes, not let it be decided. Not to be more than guilty.
That's right.
In fact, my lord, this judgment is in the context of 362.
All it will go through it.
Yes, yes.
Great.
Right.
If the transport secretary has been transferred as the
Transport
chief
secretary
secretary
has been
of,
transferred.
as the chief secretary of
But-
Andhra Pradesh, so the names could not be finalized. But that's all that happens.
Which name? No, this will not finish it off now. Give us those names given by the government.
Yes, Manoj, so that's what I was saying. The transport secretary has been transferred as the chief.
They said they will send the names.
But the chief secretary of Madhya Pradesh. So we are getting a replacement.
Some names are suggested by the.
Manoj, I was supposed to
Suggest.
suggest 3 names. Manoj, I recall that. But then the secretary was supposed to sign off on that. Now he has now suddenly been transferred to. Well, I have written instructions as the chief secretary of Madhya Pradesh. So now I
messaged my learned friend on first saying, please give the names. We will just.
So I was at the last moment given this. I have this email in.
All right. On the request made by Learned AG, list on 18th October.
There was one more issue. Can I just, Lordship, please to remember Mr. Jain had
Right.
mentioned it to me. He had sent some material on hit and run RTI replies.
Right.
Could your Lordship just take it on record? I'll just send it through email.
Right.
And just consider your Lordships if your Lordships are.
Yes,
discussing
please,
this.
please give it.
I'll just say some, just RTI replies which will be helpful. Milord.
That's right.
Grateful.
Please,
to
Greatly obliged. My lord, may I point out one important fact
Yes.
that the National Road Safety Board has been established under the Act under Section 215B, and there is no chairman, no members. It is lying vacant for last several years.
Yes.
We have moved an application for its functioning that its chairman and the members may be appointed because it is a statutory body. If your
Yes.
lordship may kindly direct the listing of the IA, then it can be
We'll
that
see now,
we
first
can
let us
be
pass the order and then we decide.
Great.
Yes.
guys.
It's like this. First informants are different, witnesses are different, club all the matters together, then grant bail, club appeals together, completely misconceived petition. And then 138, what kind of petition is this? As if the first informers have no place in our system.
Lordships are absolutely right.
And please look at it, Annexure P9, all sorts of things there. How such petition can be entertained? Now please see in which court matters are pending, even that is not mentioned. Please see page 630. This is Annexure 9 referred in prayer cause 2.
Manoj, I agree to that.
It's a completely misconceived petition. We never entertained such petitions.
That's- I-
Grant bail. Now old matters are there right from 2010, 2011. club appeals, club 138 matters, as if all courts are functioning only for benefit of one accused.
Your lordships are absolutely right, Manoj. I agree to that. And
Right.
I
Complete
apologize
misconception.
on that, Manoj. My only concern, Manoj, I'll just point out why, Manoj, why we are before this honorable court. And Manoj, all of these things are exactly what I had mentioned to Manoj, my briefing council yesterday, Manoj. This is to that extent, Manoj, going overboard in many standards. Now, Manoj, your lordships will appreciate, Manoj. I am a 70-year-old person.
And then there are petition filed before the High Court also.
Lordship-
For the same relief for clubbing the matters,
Lordships are
petitions were dismissed.
Lordships are absolutely right. Manoj.
Right.
Absolutely right. I'm not joining issues with anything. Manoj. This is my initial impression about it. Now, Manoj, the concern today is justice. 70-year-old man, Manoj. I have some kidney issues, etc. For the last 5 years, I've been, Manoj, in custody. Now, Manoj,
They apply for bail.
now, Manoj, your lordships are right. I'll just take, Manoj, 2 minutes if your lordship, Manoj, could just bear with me on that. Now, Manoj, what has happened is this, that I'm a builder, Manoj. And Manoj, for 36 years that I've conducted business, not a single case against me. 5 years back, Manoj, as Manoj, a failure on my part,
So
Manoj.
many fires are there.
Lordships are right.
There are lordships.
I'm also in fact making an endeavor, Manoj, there are some properties which can be liquidated to Manoj, return back their money. Despite the fact that Manoj, the last payment made to me was in 2000.
Yes.
Your lordships are right, Manoj. I'm quite alive to that concern. Now, my lords, the last payment which was made to me was way back in 2010, not a single civil suit which has been filed for recovery of those. My lords, I am myself, my lords, trying to build up some money to return it back. And my lords, purely a case, civil dispute, where my lords, there has been a failure on my part, my lords, to honor a promise which was contractual, my lords. And that to my lords for fortuitous circumstances. Now, my lords, my concern is just this. Please see there are 69 FIRs which have been registered. My lords, in the same thing, and my lords, 409 is not even made out. And the reason why, my lords,
That you have to apply for
not,
bail.
your lordships are right. Now, my lords, my concern is this, that, my lords, my lords, I take bail in one matter, the other matter, my lords, my custody stops running, my lords. And, my lords, then I take bail in the other matter, my lords, it will be.
You have
years.
created a situation at different places.
No, my lords, only in one district.
Right.
Only in one district, my lords. All of that in Bhopal.
In
And, my
different,
lords, in addition to that, there are about 42 cases in under 138. And, my lords, the amounts are not very large.
You have been convicted also.
Mullahs, I appreciate. Now, Mullahs, there are orders of acquittal, judgments of acquittals in my favor. On the same material.
What do you want to do? You want to withdraw?
Please.
All right. Senior Counsel Petitioner seeks permission to withdraw the petition. Accordingly, the petitioner is dismissed as withdrawn. However, statutory remedies of the petition are kept open.
Very deeply obliged, Mullahs.
Yes.
You're only requesting your lordship to take up 50.5 first.
Yes.
50.6. Just turn to 50.5.
US 50.6 also.
Yes. Just for us, I'm not even going to take the list of dates. Just take this note, it will be faster.
Yes.
Give it, please. Kindly give it to my lord. Give one each to my lord.
We will tell you our difficulty. We tried to go through the entire order. We don't know which petition before the High Court is filed by which petitioner. Because there are a number of petitions which are decided by common order.
Do one thing. Today is the last day before the vacation.
And just see, we tried to gather the facts. There may be some point, therefore we have issued notice, but it's impossible to understand.
I'm admitting, I'm not even saying it because my lord is 100% right. My request is this. Today being the last day, that exercise need not be taken by our lordships today, but the limited time available, and we will make a perfect chart and give it to us the next day. I'm only pressing 50.5 and 50.6 because of a very clear, simple liberty issue which does not concern any of the other matters.
Now, please tell us.
Yes.
Go to page 8. We tried to find out.
Of
now,
50.5, Willis?
50.5. Now, which is the petition filed by you before the High Court? There are number of prayers which are quoted.
Paragraph 7
gives the
Criminal
detail.
MP 1098 of 24 is the relevant petition for 50.5.
Right.
May not even be necessary to go to it, though lordships should know it. I mean, we are obliged to answer lordship's query.
That is the prayer for
Now, what is the finding recorded by the High Court?
straight away.
That is at page 61, no, 56.
Para 61 onwards, page 56, the Enforcement Directorate cases are dealt with. And straight away at page 125, para 144.
No. Why do you say that your arrest is illegal?
Yes, can I just take that note for less than 5 minutes? Just give that note.
Yes.
Madam, kindly give the note to me. That's all I want to say. That's all. Now, just turn to Malas page 2 of that note. After the list, scheduled offense and no proceeds of crime. How can statements recorded in such proceedings become a ground of arrest on the second ECR? Please note the
There are
date.
two things.
9th.
Had it been a case for bail, it's a different thing. You are saying that arrest is illegal. How arrest becomes illegal? That's what we are trying to find.
Because arrest is on 11th of April.
Yes.
3 days.
And your lordship's quashing is 8th of April. Now there cannot be A, new reasons to believe, B, grounds of arrest, C, material. It's not possible. Manas, your lordship, kindly see the implication of this. Your lordship quashes something in my favor. I go out of the room.
So why did you not apply for bail instead of going to very lengthy arguments?
Lord knows I have both.
Arrest reasons are not given.
Manas, your lordship
Right.
now get very rich jurisprudence on 19. My
Right.
lord knows that. The fundamental bail is, if my arrest is legal.
For us
then
also,
I
it is very
cannot
easy
bail.
to decide bail rather than going into all these
But-
lengthy facts
but-
when you are arrested. And secondly, first, how does your arrest become illegal?
4 judgments now.
Right.
Then
How does your arrest become illegal?
yes, because for arrest being legal under 19, let's forget bail for a minute, please. Arrest being legal under 19, you require one, a necessity to arrest, a ground of arrest, and a reason to believe.
Therefore, we have to examine this matter. We have to hear it finally.
I'm not a
Yeah.
demurrer. Well,
Right. Right.
Public lordship is a demurrer. Fortunately for me, your lordship doesn't have to examine. I'll tell you why. My lordship
Right.
quashed.
Unless we record a finding that proper reasons were not assigned for arresting, how do we record how do you?
Tell lordship why on a demurrer. That's the only. The peculiarity of this case is it will be on a demurrer because your lordship has given reasons. You say, Malas, on 8th of April, bad, quashed, no SO, scheduled offense, no procedure of crime, POC.
No, but there was one more scheduled offense.
No, come in.
That's what the finding of the High Court is. There is one more scheduled offense.
Now, Malas,
Right.
subsequent FIR, there are 2 more issues. I go to ACB. In the ACB, which is the Anti-Corruption Bureau, I'm sitting there.
Yes.
How does the ED come and arrest me there for a predicate offense of ACB? Third point is income tax, which is not even a scheduled offense. Because your lordship has signed a liberty, very over clever by half. You can keep on saying, well, iterative procedure. This is, well, the extreme example that your lordship releases me and in 3 days it's not possible to have
All right, we'll hear this matter.
Well, I'm saying, well, interim release will not matter at all because I've been already, well,
Right.
watched.
We'll have to hear this matter.
One more
You
aspect.
may be right also, but still we'll have to hear this matter.
There's one more aspect.
Yes.
For 50.6, this gentleman was a named accused in the complaint that your lordship had quashed, arrested, suffered ED custody,
Therefore, we are saying,
and Dubai.
had it been application for bail, it's a different thing. We have to go into all the facts. What is that predicate offense? What are the reasons? For that also, we have to go into it.
The question is, they, after your lordship's judgment, they record the statement of the erstwhile investigating officer, take all of that material, and then arrest. As if the investigating officer himself he did not even look at the witnesses.
Had it been a case for bail, the criteria is different. You want us to record a finding that the arrest is illegal, therefore we have to go into it.
And this position is admitted
Right.
in their grounds of arrest.
That's a very bad malpractice.
We'll correct it. We have been correcting
Because you arrest me, don't
it in several matters, but it has to be done properly.
That I understand whether time is short, but just consider this. Now this new practice, at least in the other cases we have not seen earlier, you are frequently now not making me an accused. And then the court says, you don't need my permission. You already have the permission to arrest. You, Malas, don't make me an accused, you arrest.
Yes.
Because the Tarsem Lal judgment of your lordships says that you can't just show necessity to arrest without being an accused.
No. That judgment operates post-complaint. Post-complaint.
Here, they had filed that first complaint
Your
against
Lordship is
50.6 and 4 others. So 50.5 did not make him an accused on the same material. He is now have only one paragraph, page 350.
No, so tell us how many complaints are filed against this gentleman, Anil Pateja.
Now filed now. Only one. In the first file complaint which your lordship said he was not made an accused. I'll read out one paragraph of their grounds of arrest. That the predicate offense FIR, documents including the statements recorded under section 50 shared by Thandilal Meena, assistant director in the quashed complaint filed by the IT and the...
Therefore, A, we have to find out whether there is a predicate offense on the basis of which second ECR is been registered. B, we have to find out, we have to read what are the grounds of arrest. We tried to search from your petition, we could not locate even the grounds for arrest.
No, this note is better, well, that I understand. This paragraph I is reading shows that they use the quashed material. Because they use your lordship's quashed material. This paragraph shows that.
One second. Now, please go to the in 50.5, we tried to search where are the grounds of arrest supplied to you. Where is the copy of grounds of arrest? At least on the index, we could not make out.
In
Section
50.5.
24, page 355.
Page 24.
50.5.
Yeah.
Annexure P24, page
Now,
355.
right.
Please come to 359, para.
See, the problem is, if you bulky just to show that matter is important, this is kind of thing happens. Here, what was required was earlier order, copies of FIR, copies of ECIR, and copy of ground of arrest. But you will make it so bulky that will require more time to read it.
The difficulty was
Right.
because there was an entire
Right.
earlier round. But
So I made this note, Malas, this notice.
So we'll go through it, we'll keep a date on it. Yes.
Yes. Can there be material justifying a section 19 where that investigating officer has?
Therefore, we have to examine that. What are the grounds of arrest?
It goes to the-
What was the material? We have to examine that. We can't, that's what we are saying. Had it been a case for bail, we don't have taken.
May I make one request? May I make one? Kindly give me the first proximity available
Yes.
to lordships and separately these two matters. Malas, clubbing
Yes,
can
but don't keep it to
clubbing
physical
can go on.
matters.
One second.
Predicate offense, ma'am.
Therefore, we, just,
Clubbing, non-clubbing can go on. Kindly have this separate.
There I agree with Manoj.
no, just 1 second. Now we have the list of these matters.
Yes.
At serial number 50.
Now, we've made a chart.
50 is over now.
49 and 50 are over. 49 will be adjourned to 18.
49, we are not club.
Yes.
Now, right. Just 1 second. Now, which are the matters where challenge is to the arrest?
We've just handed over the chart.
That's this chart.
Only two matters, 50.5 and 50.6.
Which are against ED only. 50.5 and 56, they are against ED's wrongful arrest.
50.5
5 and 50.6.
Now, if your lordship just have the chart. First one is clubbing petitions 50.1, 2 and 3 on
Yes.
page 1. Bail cancellation, which is by state of Chhattisgarh, which was item 49. Your lordships have already.
So item 50.5 is for challenging the arrest.
And 6.
50.6.
50.6.
They are the only two, Malas. Tuteja and Devar.
Now, there are no other matters in this group for challenging the arrest.
None against ED. Against ED.
No, and also nothing challenging ground of arrest as well. I mean, the 19 illegal arrest, as my lord puts it.
Just take down. Right. We'll come to that one. Right.
No, I don't. My lord,
That's why
No.
I'm not.
Is there, see, there's 68 also. Along with 68, there's 68.1. Are these matters where challenges to the arrest by ED?
No.
Washing order. Right.
These are SLPs, sir. These are SLPs
Just
arising
those two are
out order of the High Court.
Just 1 second.
Yeah.
So,
Only
serial
two
number
matters.
50.5 and 50.6
Correct.
Yes.
shall be separated from the group and shall be listed at the end of the list on Friday, 18th October. Now, what is serial number?
Malas, let the counter rejoin to be completed, Malas.
1 second. Now,
Let the counter rejoin to be completed, otherwise they'll take time again, Malas.
right.
Counter rejoinder, etc. All.
We make it clear that
ED.
the counter shall not be accepted if filed after 15th of October 24. Now, what is 50.1?
Now, by 50.1, 50.2, and 50.3 are all cases for clubbing of the FIR. They did petitions for clubbing.
No, so 50.1 is for clubbing, 50.2 is also for clubbing.
Yes, and 50.3 is also for clubbing
Right.
of 2 FIRs. Now, my lord, I have a preliminary issue there, but my lord, your lordship may fix any date for hearing this.
50.1, 50.2 and 50.3
Yes, my lord, they are of the same type.
shall be listed on
Pleading the complete, my lord, the state has filed its reply.
shall
Both the states.
May I make a
shall
suggestion?
be listed on 4th November 24. Yes.
My lords, I was only making one submission here. There is a batch of quashing and there is a batch of clubbing. Now, quashing is also premised on the TT Antony principle by and large because you have FIRs.
So we are wondering why you are applying for quashing and clubbing, right?
Alternative because if
All right, just one by one, they are giving dates now.
the principle very well and done well. But otherwise, then my lords, they will require to be clubbed. So what I'm saying is,
Right.
put quashing on the top Let the clubbings be put thereafter. They can be kept one after the other, and my lords may
Now-
to take that.
Now the question.
But according to us, the consolidation one, the clubbing are infructuous.
One second.
Now they are Chhattisgarh.
Now, we'll deal with
Chhattisgarh SLPs.
68.1.
No,
That's
Sorry,
not this,
50.
4.
1 second, there is some.
50.4 million.
Now, first order is in 50.5 and 50.6,
Yes.
where we have kept it on 18, correct? Then there are three matters, that is 50.1, 2 and 3, they are on 4th November.
Yes, Manoj. Now the quashing.
Washing now.
Passing is now, which one?
Serial 6, 6, 7, 50.4, 68.1,
68.
and 68.
My lord, 68, 68.1.
50.4, 68 and 68.1. These are the three. which are for quashing.
50.4, 68, and 68.1.
Yes.
The SLPs form an order refusing quashing by the Chhattisgarh High Court.
8.1. Order on
29.
3rd of September.
Who? Niranjan Das.
All right, yes.
Niranjan
Right.
Das.
They have to be kept on a particular day for hearing. That's the only thing.
Say he's on 60.1, just one, right?
Then 50.4, 68 and 68.1.
Yes.
List on, so you say, same list on 4th November.
Yes.
No, I have only.
For the congress statement that I was, one time I have appeared before that.
You file an affidavit to that effect.
No, I just want to say one thing.
If the state wants to file any counter or anything in these SLPs, they may wish.
We have already filed.
Filed them.
Much.
Every matter counter is filed.
Where we have filed in both the quashing and the consolidation. Everything, reading the completed so far the state is.
So the
No, just 1 minute.
After midnight this morning actually.
No, just 1
I'm at 3 a.m. in the morning.
That's right.
So my lords have rightly
No,
passed that order.
No,
that
they are filed.
late.
They are filed in the morning of this morning.
This morning at 2 a.m.
But that really doesn't count as filing. If it-
Sorry, Lordship said to file it within 2 weeks and we file it within 2 weeks. Now, just one, there is just one issue, Manoj. In 68, not 68.1, just as my learned friend said, that his client appeared pursuant to a summons. There are no coercive orders based on a statement which I gave in the High Court, which is now dismissed. But anyway, Manoj, in 68, your Lordship said comply with the investigation, cooperate with the investigation. So we issued him a summons to appear on the 24th. He said, I'll come on the 27th. We said, all right. He didn't come on the 27th.
All right, we see, examine that. Wherever interim orders are there, they will continue.
Well, my apologies for mentioning item 16. Well, this is the matter your lordships granted notice on regular bail and said you go to the High Court for extension of interim bail. My lords may just clarify because now the matter is here. Otherwise, the High Court won't, my lords, enter. So my lords may say the pendency of the regular bail won't prevent me from approaching for extension.
Number 16,